Hello, and thank you for visiting Graphene Business Law. My name is Pamela Matani, and I'm the founder and principal lawyer here at Graphene. If you're new to our YouTube channel, please go ahead and click on the red subscribe button down below. At Graphene, we regularly post content that is most pertinent to business owners, small business owners, and entrepreneurs. Of course, we have a few other series on the channel as well, but our main focus is geared toward our primary client base. And of course, that includes clients in Toronto and generally within the jurisdiction of Ontario. Today, I'd like to take the time and discuss a clause that I find is the most confusing for the clients we work with and most confusing for business owners and persons entering into contracts more generally. And I'm not sure if part of why the clause is confusing is because the title of the clause itself is not intuitive, or the clause, once you get into the nitty-gritty of it, can be quite difficult to understand. But for a host of reasons, this clause more often than not puzzles the average client, and that is indemnification. Okay, indemnity clauses. You may or may not have heard of these clauses. They are common to be seen in contracts. However, they are also quite complex to put in those contracts in ways that are most helpful to you as a business owner or entrepreneur. The goal for today's video is that you come away with some very high level understanding of what indemnification is and what indemnity clauses do by way of general gist of the matter, and so that the next time you're speaking with a legal professional, with a lawyer, you are able to better understand what that lawyer is saying to you. Here at Graphene, we can certainly help you draft these clauses and help with your contractual draftings more generally. But the more you understand about what that lawyer is saying to you about this section, the better you're able to reflect your authentic needs and desires as a business owner and entrepreneur as regards all sections of your contract, but indemnity included. I want to point out right from the beginning of this video that this video simply cannot be a indemnification toolkit 101 for the average viewer, and that's because this is such a complex topic. Indemnification, you'll see it surface in case law, is one of the most heavily litigated contractual provisions, and for a whole host of reasons, that is just a reality of the game. These are complex clauses, and this video, again, the best case scenario is that it better equips you in talking to the right people that can service your needs legally when it comes to reflecting your interests, indemnity included. And of course, those people should include in your team legal professionals, should be included in your team of persons helping you with such a clause. So with that out of the way, indemnification clauses are also referred to as hold harmless clauses or hold harmless provisions. So right away, when we're thinking about harm, on the other side of that is risks are contributing to harm. And that is a good takeaway right from the beginning, because indemnification clauses serve as a very important risk allocation tool. Some of the clauses in a contract are very intuitively named. You'll have clauses that speak to the formation of the contract, and you'll have clauses literally titled termination clauses that speak to how you can end or get out or terminate the contract before you. Indemnity is not one of those intuitive clauses, and it just isn't, okay? But it is a risk allocation clause. That's something you should know big picture. In terms of the risks we're talking about, where are these risks coming from? There's a lot of risks that can present themselves in the course of your business dealings with another party. That goes without saying. That's a reality of doing business. However, when it comes to indemnity, we're looking specifically at risk arising out of either party's breach, negligence. That includes negligence with other parties, not in the contract, and misconduct. okay? I want to repeat again that having a lawyer involved in the drafting of your indemnity clause and your contract more generally is extremely beneficial to the process of drafting this clause to best reflect your needs, okay? I did mention earlier as well, these clauses are very heavily litigated, and as a result of that reality, going into the drafting of an indemnity clause, you should be prepared to negotiate, or by should be prepared, of course, I mean you as a party, but in your party, you know, on the side of your party, on the team of your party, should be a lawyer. So when I say you, keep in mind, I mean, you know, please include a lawyer. But you should be prepared to negotiate these clauses heavily ahead of agreeing them, because when we know that these clauses can become so tumultuous down the road, it is so worth taking the extra time to ensure that what you're agreeing to reflects your interests as best as it can. I'm just moving my screen there. I do have a few notes. I have a few notes for you. So that being said, what is the main benefit of an indemnity clause? The main benefit of an indemnity clause is to protect the indemnified party from losses from third-party claims made pursuant to an agreement. Now you'll notice the wording of third party. This isn't that section that's going to help the two parties to a contract, party A and party B, you know, best sue each other in case times get rough. This is a clause that is triggered when third parties are intervening into your contract, or intervening, with one of the parties involved in this contract. And as pertains that hold harmless aspect, who gets held harmless? Well, indemnifications can be mutual or one way. And that again depends on your desires and the other party's desires in entering to this contractual agreement. In a mutual indemnification, each party agrees to compensate the other party for costs or damages arising out of the indemnifying party's breach, negligence, or misconduct. In a one-way indemnification, only one party provides that indemnity or that protection to the other party. Now, there's a lot of reasons for which this clause would be mutual, and there's a lot of reasons as to why it could be a one-way. What matters as a starting point when you start these conversations with a lawyer is that you're best aware as to what your interests are, and a lawyer can help you, and what your desires are out of the different clauses in the contract, and a lawyer will of course help you translate that into the best, most legally adherent language possible. Generally as well, you should know prior to agreeing to an indemnity clause, what liabilities does it cover, or what liabilities are excluded as well, okay? There are many ways through which to limit the liability of the indemnity clause, so the amount for which one party will hold the other harmless, or in the case of a mutual, that both parties will help each other out for. And dollar amounts is certainly one of the ways through which you can limit your indemnity clause. Okay, and that dollar amount should be agreed to by both parties. You can also limit this clause to third-party claims only. I mentioned earlier that this clause we're looking at, generally, we are looking at one party to this contract having had something go wrong in dealings with other parties outside of the contract, okay? And there should also be an eye to covering certain breach, negligence, and willful misconduct acts through these indemnity clauses. So I'll pause the video there, because I think at a high level, this video, or this time, you know, spent on the video helps you walk away with a few key concepts or key words or key points as pertains to indemnification clauses. They are risk allocation tools, risk allocation oriented. They can be mutual or they can be one way. They can limit a whole host of actions, of behavior, and having a lawyer involved in drafting them prior to agreeing to them, of course, is really beneficial for you and your business. So those are some good takeaways. I hope that this video has been helpful, and more than that, I hope that it helps you have a more meaningful conversation next time you're speaking to a legal professional as pertains to these indemnity clauses and why you need them. They are very common. However, them being common doesn't necessarily help you and your unique interests as a business owner. And that's where you need the right team to help you. That being said, here at Graphene Business Law, we're knowledgeable and we're equipped on helping you draft these clauses, indemnification clauses, drafting contracts, more big picture, of course, and helping with all the steps of your business from launching it to growing it to concluding it, if that's where you're at. So I'll end the video there. Thank you for watching.